So, you will remember that recently the Supreme Judicial Court of Massachusetts ruled against Karen Reed. And we went over the Supreme Judicial Court ruling, which said there is no verdict. Therefore, there is no double jeopardy. Even if the court allowed all of the jurors to come in and say, yes, we rendered verdicts for Karen Reed of acquittal on counts 1 and counts 3, which are the most serious counts in this case. There is still nothing that can be done. The jury has been dismissed. They cannot be reconvened now to render a verdict. The only thing that could come from that is A, the defense could glean more information about what the jurors thought was important or not. And B, they can do that if the jurors come forward, which some have. And B, it might pressure the Commonwealth to dismiss those counts, which seems real unlikely to me. But they can't reconvene a dismissed jury. A mistrial has been declared, and there's no way to undo that. It's why we also saw the defense arguing that the judge did not need to declare a mistrial, because that's really the only way to get around this. And even then, if the defense won, the result is you get a new trial. That's where we're at. You get a new trial. So there isn't a remedy under the law for the circumstance we find ourselves in. So no person shall be subject to the same offense to be twice put in jeopardy of life or limb. The underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which they are stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. That's from Arizona v. Washington, 1978. We know what double jeopardy is. The question here is, was there a verdict? What can you do about it? The second argument they are making is that there is no manifest necessity to declare a mistrial. The standard of that is judicial discretion. The appellate court's not going to see an abuse of discretion here, given all of the facts. They're just not. The First Circuit's decision in the United States versus Tribio Lugo, I might have said that wrong, 2004, provides a helpful analog. There, in the midst of a trial, upon noticing that only 11 jurors were present, the judge consulted with both the prosecutor and the defendant's lawyers, outlining two options. Either postpone the trial until the 12th juror could be located, or proceed with a jury of 11. What? Where's that okay? Defense counsel conferred with their client and informed the judge that the defendant did not wish to proceed at the moment with 11 jurors, but rather would like to wait for juror number 12. Shortly thereafter, the judge learned for the first time that the missing juror had been absent during some or all of the earlier portions of the trial. How does that even happen? There's 12 seats. How do you not look at the seats and go, huh, there's a butt missing? That's strange. The judge then announced that he was going to declare a mistrial because only 11 jurors had heard the evidence and he did not believe there was any other way to cure the defect. The trial judge denied a subsequent motion to dismiss on the grounds that a mistrial was required by manifest necessity because only 11 jurors remained and the defendant had refused to proceed with fewer than 12. Well, what did the case do? What did they do? The First Circuit reversed. Really? Finding that there was a clear alternative to a mistrial, proceeding with 11 jurors. The defendant didn't consent to 11 jurors. That's an odd result, because if you had forced the defendant to proceed with 11 jurors, and then they were convicted, the defendant would have said, I didn't consent to proceeding with 11 jurors, and then we would be in a difference. Odd. This is odd. But they are finding case law that says there was no manifest necessity to declare a mistrial. When the district court had tentatively explored that alternative, it never exhausted that alternative. The court never offered the defendant a choice between proceeding with 11 jurors or accepting a mistrial. During the pertinent time frame, the court made no effort to ascertain the defendant's attitude or wishes with regard to the possibility of a mistrial. In view of these omissions, the record compelled a conclusion that the jury of 11 alternative was not adequately explored. This conclusion was dispositive because where there is a viable alternative to a mistrial and the trial court fails adequately to explore it, a finding of manifest necessity cannot stand. Well, then what's the result? I'm going to zoom real quick to the First Circuit Court of Appeals and see what their treatment says. We're on a side quest, y'all. 4 days into a criminal trial, the district court discovered that a juror had been absent for some time and, having previously discharged the lone alternate, declared a mistrial sua sponte. The defendant thereafter moved to dismiss the indictment on double jeopardy grounds. The district court denied the motion. This appeal ensued. After careful review, we conclude the lower court erred in refusing to dismiss the indictment. That's the point I wanted to see. If no manifest necessity, then dismissal. That's what I was looking for. The defense has refined their argument and is arguing that because polling the jury was still an option, there was not a manifest necessity to declare a mistrial. And because polling the jury remained an option and there was no consent of the defense to declare a mistrial, therefore, the appellate court should find there was not manifest necessity to declare a mistrial and dismiss the indictment on those grounds. That's the second level of the argument. Putting the jury stuff aside, because the jury stuff is kind of a non-starter, there is a legal path forward for the defense to get a dismissal if the court finds there wasn't a manifest necessity. Now, I think the fact pattern in the Reed case is not as wild as the fact pattern here because of how clear the notes are, but it's a door. In their habeas motion, the defense is asking for the federal court to grant their appeal, essentially, finding that the Supreme Judicial Court of Massachusetts erred and that the court must find that Karen Reed cannot be retried on counts 1 and 3, and that doing so would subject her to double jeopardy because the jury acquitted her on those counts. They argue on similar grounds that they argued at the Supreme Judicial Court, but I think the arguments in this briefing are refined from the prior arguments to the Supreme Judicial Court, and that's by nature of the fact that they're taking the Supreme Judicial Court ruling, pointing out where they disagree and say, we disagree here, here, and here. The most difficult grounds for them in this is arguing that the jury in fact reached a verdict, and therefore this is double jeopardy. We have seen the case law in Massachusetts. The case law is pretty well settled that a jury verdict has to be not only marked, but also stated in open court. That is going to be a more difficult argument. But the legal path forward on that is still the argument that they made at the Supreme Judicial Court regarding whether or not there was manifest necessity to declare a mistrial. And we actually took a little bit of a side quest into a really interesting case that was overturned where the First Circuit found that there was not manifest necessity to declare a mistrial because the court had not explored all of the other alternatives with counsel and the defendant. So were there other options than just saying to the jury, I'm not going to send you back to deliberate, I'm declaring a mistrial? And what were those other options? And the defense in their briefing argues that the other options here were to poll the jury, to clear up any misconstruction, any ambiguity about whether charges meant count 1, 2, and 3, or whether charges meant count 2 because count 2 had multiple subparts of lesser included. And the defense walked through an argument of the jury instruction saying, look, in context, the jury instruction says do not come back to the court unless you've reached a verdict on all counts. And that can cause confusion. And then they walked through, look, if you look at count 2 and how many charges there are, and you take that in context of what the jurors have said after the trial, it's clear to the defense that there are 2 readings of the jury notes and an inquiry before declaring a mistrial is what would be necessary before finding a manifest necessity to declare a mistrial. Legally, it's their best path forward because the jury issue is pretty well settled in case law. Now, they've cited some case law that I do not recall from their arguments to the SJC that point out other cases where, when there were multiple options, the court found, and the First Circuit found, even not finding fault with the judge, but saying, we do think there's other options, and then ordering the case be dismissed because there were other options and a mistrial was not necessary. I think it is legally their best path forward, because even if they inquire from the jurors, there's not really a path to reconvene the jury and let them render a verdict. There is legal precedent for saying the judge declared a mistrial too fast, and therefore what's required is a dismissal because jeopardy still attaches to those counts. So they are asking for counts 2 and 3 to be dismissed on the argument of the mistrial being declared too quickly without alternatives explored, and because the jury said they reached verdicts, and then asking at the end of their argument to poll the jury and pulling up other circumstances where that's been done, which, though I would love to hear what the jury has to say, the Supreme Judicial Court was pretty clear on the case law of the land that that is not going to be a door that the courts are opening. Could the federal courts interpret that differently? They could, but I think the manifest necessity to declare a mistrial argument is legally the best path forward for the defense if the courts agree. The Supreme Judicial Court disagreed and said these notes are incredibly clear. And I think the defense put their best argument forward, laying out the context for that argument, laying out case law where there had been context where the judge declared a mistrial without exploring different avenues and then moving forward. And they point out that in all of the conversations with the defense and the prosecution, that the questions were, hey, do we give the Tui Rodriguez instruction telling the jury to go back and try some more, or do we not give that instruction? There was not a conversation with the defense of, if we declare a mistrial, is it needed? What else would you like us to do? And they point out that difference to the court, saying, we only ever discussed giving that instruction or not giving that instruction. We never discussed what comes next. That means all the alternatives weren't explored. And we are asking this court to fix that ruling and dismiss the 2 most serious charges in the case, which are that count 1 and 3. The Commonwealth has until Wednesday, February 26th to respond. Then Karen Reed's side gets to file their reply by February 28th. Arguments will be heard in federal court on this March 5th. That's not all that's going on in Karen Reed's case, though, because the defense has until Friday, February 21st to file their motion to dismiss. And then the Commonwealth will be responding to that motion to dismiss that's going to be going forward on what we largely believe to be Brady grounds and discovery grounds in state court. And the hearing on the Brady motion to dismiss is set to go forth on March, 4th and 5th. So there is a hearing in state court set for March 4th and 5th. There is a hearing in federal court for the habeas appeal on March 5th. And there's a hearing set for Friday, February 25th to continue the rest of the hearings that were abruptly stopped yesterday on February 18th. This case is set to go to trial April 1st. No, it's not a joke. And there is so much litigation that is going to happen in the weeks running up to April 1st. It's going to be a lot to keep up with. So get the Lawnerd app, because if you're like, what is going to happen? Who knows? Who knows in this case? There are 2 motions that can be dispositive, but the defense on the habeas is asking to dismiss counts 1 and 3 and pare down the trial to just count 2. The motion to dismiss is going to ask to dismiss the entire case. So there's a lot of litigation left to come. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Lawnerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.